afternoon, everybody. Thank you so much for joining us. My name is Alex Hoffman with Equipment Dealers Association. Before we get started, a couple housekeeping things. We are going to break for questions a couple of times throughout today's presentation, and then again take some at the end. At the top of your screen, you'll see a little panel where you can click Q&A. You have a question, type it in there. It gets sent directly to our panelists. They can either type directly back to you if it's a fairly specific question, or we may choose to answer it out loud for the group if it has a broad application. So feel free to use that. We welcome any and all questions, and we will go ahead and get started.
Well, again, thank you everyone for joining us. My name is Natalie Higgins. I'm General Counsel here at the Equipment Dealers Association. We're joined today by some excellent presenters that are going to provide you with some very valuable information from the law firm of Armstrong Teasdale, located here in St. Louis, Missouri. We have Nick Garzia and Carolyn Theis with us. Nick and Carolyn both work closely with their clients to ensure that their clients implement and adhere to safety or to policies and procedures, which help them protect their security interests arising out of mechanics liens. So we're very grateful to have them here today. And with that, I'll turn it over to Carolyn.
Actually, turn it over to Nick.
Oh, sorry, I'll turn it over to Nick.
So, Nick Garzia, I just want to thank everybody on the call. Thank the Equipment Dealers Association for a chance to present, and Alex and Natalie for this opportunity and helping us advance these slides as we go along. I always like to start presentations with a joke, but I have to confess I couldn't think of one single joke that had to do with agricultural lien law. So we're just going to plow ahead. That was a joke, it was a pun. All right. Sorry to all on the call. Carolyn, would you map us through the agenda that we're going to discuss on the call?
Sure, I'd be happy to. The goal of our presentation today is to explain the fundamental aspects of building policies and practices to protect dealership interests. So we are going to walk through the basics of mechanics liens as well as other statutory liens, their procedural requirements, which vary considerably between states, how to sue to enforce your rights under these statutes and other laws, how to defend your dealerships with best practices, how to defend your dealerships with common defenses, and throughout our presentation, we're going to be answering questions. So feel free to send us those, and we will answer them throughout the presentation. Nick, turn it over to you.
And just a more informal objective here. We're just going to talk about a series of laws that exist in all 50 states and in the Canadian provinces. It's probably thousands of statutes, and it'd be hard to go through each and every one of them. So, kind of the practical purpose of our discussion would be to give an overview of these laws, to allow participants on the call to be able to issue spot as these come up in either your business or your customer's business. Moving forward, these laws, we're calling them mechanics liens and statutory liens. They exist in the agricultural law systems to enable equipment dealers and their customers to secure the value of the services they provide, either the labor of the person using the equipment or the equipment dealer itself, to the productive outcome of the use of that machinery. And there are statutes and a series of laws that apply in different contexts. And over the next several minutes, we're going to talk about the four main types of these statutes. These are effectively methods that the government has put in place to allow service providers to have additional security to ensure that they get paid. So we can move forward to the next slide. So just a note on the nomenclature we're going to use in this presentation, because this has already come up as a question. There's a terminology that's used quite frankly as a mechanics lien. But what we're really talking about are, as I said before, quite literally hundreds of different types of liens for different scenarios. Many of just going back in history without boring everybody in the room and on the call, this is an innovation of law that we can take credit for in North America. It is these laws date back to the early 19th century, in which we were nations that were quickly growing. We were growing in the commercial, industrial context, but also in the agricultural context. So we needed some laws that would assure that the people actually doing the building would get paid for their services. We wanted to encourage this building. So beginning in quite literally Thomas Jefferson's time in the early 19th century, we started to put laws on the books. Now at the time, the word mechanics literally meant people who worked with their hands. It didn't have the context that we have today as somebody who works with automobiles or machinery. It was a generic term that meant all craftsmen, carpenters, blacksmiths, and people that did construction and erection of barns and agricultural improvements. So it's a generic term. So what we have today, we have a series of laws that are called mechanics liens, but they actually have nothing to do with people that work on our cars and farm equipment. The term mechanics lien generally applies to, it means a statute that protects people that improve land. In Canada, several of the provinces have just used a more practical term, building lien. So when we're talking about mechanics lien, the purpose of this conversation, we're talking about one specific type of lien instead of the generic system of all these statutes pulled together, which we'll just call statutory liens. So to avoid further confusion, we'll proceed. Generally, we're trying to lump together all these different laws. Generally, can you go back one? The lien systems, as I said, are put in place to allow automatically, as a matter of law, a person who provides valuable labor, material, services to their property or equipment, a right to collect from the benefit of that. And as we'll see in several contexts, they tend to be very specific. So each state statute, we're going to see a selection of them, involve very specific preconditions for perfecting a claimant's interest in the property. So it's going to be very important to understand those laws that apply. We're speaking generally here today, but in each state there's a system that apply generally to things like liens on real property, liens on vehicles and machinery and equipment that is serviced, and then even liens that will allow a provider of equipment to obtain a lien on the actual crop itself that's collected and processed as using the equipment that has been leased out. This is very, very important, and I would underscore, and if you could see me, I'm not literally standing on the table, but imagine me doing that. This is extremely important in the construction context when equipment dealers procure expansion of existing facilities or construction of new facilities. Mechanics liens that apply to the development of land are extremely important, can have serious consequences to an owner of the project. So now we can move forward. Without just repeating again, as we talk forward, the one caveat is I'm speaking in generalities, and the specific state laws are going to be different in each state. And underscoring again that when the statutes lay out specific requirements, if they are not met, courts generally do not have any discretion whatsoever to bend the day. So if a deadline says a lien needs to be filed by January the 1st, if the lien is actually filed on January the 2nd, generally those are almost as a rule they are discarded. So as we're talking and mentioning deadlines are extremely important in the context of mechanics and statutory liens. You can advance to the next. And again, before we start talking in particularities, most statutes that are applied to mechanics liens or other agricultural statutory liens have followed the following process. They have legal conditions that arise that give right to give right to assert a lien, and that's generally in the context of, for example, improving. One example we'll talk about when real property and land is improved by a building, the provision of labor, material, or equipment is the legal basis for having a right to state a claim. The next step generally is going forward and filing a formal statement of the claim, and that's done, as we stated before, strictly in accordance with the requirements set forth in the applicable law. And then generally the third step after filing a statement of lien is to initiate a lawsuit to obtain a legal judgment to enforce the lien. And what's an interesting hallmark of the liens that we're talking about is in our system in North America, once a judgment of lien is obtained, a judgment creditor with a judgment of lien can ask the court through the sheriff to seize the property and sell it to secure funds to pay for the underlying labor material service that was provided. So For the person who doesn't pay, this is a mechanism for them to lose their property and make sure that the party that gave value for that property or equipment gets paid. We'll note that there are some sticking points. Having said that, that usually have to deal with the interests of the bank or the lender, which can add a wrinkle to that. So I want to speak about one particular application, which is again very important. And I start with this first. I know this is a group. I know this is our main focus here is liens that would run with the actual leasing or sale of equipment. But I want to talk about liens on land first because it's very important for at least this reason. As I was speaking before, the concept that a person that assists with building a barn or constructing a factory should be provided a means to get paid was an early decision we made. And from that concept of the traditional mechanics lien or lien on land, later derived other liens that we'll talk about that apply in more of an agricultural context. So just want to start very preliminarily with the original type of mechanics lien. We have in one form this lien on land in every state in the United States and all the provinces. We don't have it in Puerto Rico, if there happens to be anybody on the call from Puerto Rico. They derive their law from Spanish law and never incorporated this context. But as a generalization, most of the mechanics lien law or liens on land would allow for a party that provided labor, materials, services for the construction of an improvement or a building or grading or even excavating a parcel for later construction, the right to state within a specific period of time a claim on that property. So that's done in the form of a mechanics lien statement. If a party that provides labor for material services is not paid by the owner, then that party still requiring payment can record either in the land records or with the records of the court a statement of lien. And most state statutes provide that a lawsuit would need to be filed within as soon as 30 or as much as 2 years following the time of performance of the work. So for this group, this may come into play most significantly in the context of a construction of a new facility, new repair facility or warehouse or showroom. We're going to talk about later about things that we can do to protect against this lien, but this is the understanding the potential for a service provider, a contractor, a plumber, electrician to assert a lien on the physical property could be very important. And the method an owner would use to protect itself would be to obtain lien waivers at the time of making payment. So I want to just take a quick look at an example on the next slide. Since we're here in Missouri, I thought we'd start with our snapshot view of what our statute looks like. A Missouri statute makes available for the right to claim a mechanics lien to general contractors, subcontractors, sub-subcontractors, or lower tier subcontractors. All suppliers, including rental equipment suppliers, landscape architects, engineers, surveyors, well diggers. So Missouri has a very broad statute in terms of who can make a claim. Other states like New Jersey cut off, they require that a person has to have 1 degree of separation from the owner before they can make a mechanics claim. So these vary from state to state. And our statute covers not only the labor, materials, and equipment, but it's very broad. Again, it covers people who move the dirt. It covers architects who design buildings even if they're not built. So Missouri is on the very broad spectrum of who can assert a lien. So owners in this state should be very proactive in making sure that when they're contracting out for work, they're obtaining lien waivers. They're making sure that when they're paying their general contractors, there's means in place to make sure that none of the subcontractors or suppliers can come back and assert a lien against the property. So we have more to state just on the next slide. No need to study this particular requirement in Missouri, other than to know, I just want to just show that there's a very hyper-technical set of requirements for the actual lien claimant to follow. So, and I could talk for an additional hour, I promise you I won't, about how to comply with this lien statute, this particular one, but it's very, very particular. So one of our requirements is that a contractor needs to provide a pre-lien notice to the owner, basically saying that before the work even starts, we have a right to assert a lien, and contractors that don't do that lose their lien rights. So I'll show you on the next slide what that looks like. So without doing too much on this, moving to the next slide. Again, just illustrating the hyper-technicality of these statutes. The lien claimants, some lien claimants are required to file a notice of intent, so it needs to give the owner pre-lien notice of intent to file the lien claim. And then in Missouri, at least, there's a need to file a lien within 6 months of the last date of actual performance of the work. I'm working on a dispute right now in California, in which there's quite a few lien claimants, but we had a certificate of substantial completion from the architect that essentially serves as a cutoff date. So in California, there's generally 90 days to file a mechanics lien. So we with the owner waited patiently for that 90th day to come, and anybody who filed a lien after that, we're telling them they're out of luck, they're not getting paid. So just using Missouri's statute as an example, there's another really quirky requirement that that the lien claimant provide a very, very detailed description of the work that was provided. And then finally, using the state as an example, a suit needs to be filed within 6 months. So if a mechanics lien is filed on January the 1st and no lawsuits commenced by July the 1st, then the owner escapes any consequence of the lien filing, because the lien filing is nullified if a suit's not commenced within 6 months. So next. Traditionally, and the next kind of species of lien that we're talking about are liens on land, specifically for those who provide rental equipment for any alteration of it. In some states, traditionally, this was rental equipment providers were not allowed to assert a mechanics lien. The thought was that a mechanics lien should only be available for those who provided labor or services that were incorporated into the actual improvement. And rental equipment providers were out of luck because, you know, they did not provide any nails, wood, they didn't swing any hammers, they didn't provide any workforce. So in some statutes were written, again, using the terminology that originated in the 19th century, we're out of luck. But in the last 50 years, most of the mechanics lien statutes have been amended to allow the service that provides a rental equipment, so it could be in the context like a backhoe or a skid steer or something that, crane, that is actually used as an implement to move forward with the construction of a project, rights to assert claims of lien on the land. I'm going to continue to use, I promised you last time, Missouri statute as an example. However, as these specific requirements to protect rental equipment providers were written into the statutes, the mechanics lien statutes, they also came with some with a few additional strings that would not apply to carpenters and bricklayers. So in Missouri, there's a minimum amount that can be claimed. It applies only in the commercial context and not residential. And there has to be a notice, certain notices provided while the work is in process in order to enforce that right of lien for rental equipment. But this is again, we're going to talk about tips later, but the takeaway for anyone on the line who actively rents any equipment that can be used in improvement of real property is to identify at the time of the rental where the property will be, where the equipment will be used and what it will be used for. I'll say that again later, but wanted to mention it while we're speaking about this type of lien.
We're going to take a quick break to answer some questions that have been submitted. A few of you wanted to make sure that you were going to receive a copy of the PowerPoint deck, and that will be circulated to all of the registrants after the presentation. Our contact information is included on the first and last slide. We understand that You may have specific questions or issues that arise later related to mechanics and other statutory liens. Feel free to reach out to us directly with those questions. As Nick mentioned, these are really technical statutes that vary significantly across the states, and they're very important to many of you. We also have a question submitted about priority. The question is, does a mechanics lien always have priority, or is it dependent on the state? Nick?
Dependent on the state. In some states, yeah, the mechanics liens will have priority over prior rights of lien by the purchase money lender. However, I will say, as a general rule across the country, there are carve-outs in the law that do allow, that reflect a preference for giving a mechanics lien claimant a priority over a lender. So, I mean, I promised I wouldn't use Missouri as an example again, but I will. I'll break my promise and do it in answering this question. In Missouri, there's a legal doctrine. It's not written in the statutes, but it's been recognized by the courts, called the waiver doctrine, and basically says that if a lender actively participates in the planning or of a construction project, they waive priority of their security interest in the land to subsequent mechanics lien claimants. Now, other states have taken the position where they expressly exclude that. They say if lenders that have recorded a deed of trust or a mortgage have absolute priority over any other improvement or any other lien for that matter that could take place. So again, depending on what state the question is being asked. However, it's always a good practice, especially if you're listening to this in a context in which you may want to assert the claim, to evaluate where priority may fit. Now, nowadays it's very rare that there's not property that's encumbered by some sort of prior security interest. So it's becoming increasingly difficult to enforce mechanics lien laws for that practical reason.
Thanks, Nick. We have two more questions that actually I think might tie into the second portion of our presentation. As Nick mentioned, these first two topics related to liens on land. And the next section of our presentation deals with liens on crops and equipment. Nick, I'll go ahead and read these questions and you can decide whether or not to answer them now or hold off until the second half of our presentation. The first is, do we have the right to hold a piece of equipment after the work has been done, before or after a lien is filed?
We'll answer. This is after we move on. We will discuss specifically the repairman's liens. Is the term I'll use, and the answer is going to be, again, depends on what state you're in. But as a general rule, yes, there's certain specific requirements that must be followed depending on the state you're in. But yes, there's actually multiple theories on which you could do that.
The second question is, what constitutes improving the land for farm equipment? For instance, if we lease a tractor, which is used for tillage work, would that qualify?
And the answer is, we're going to talk about those specific liens, but yes, those liens. We haven't got there yet, but we're going to talk about liens that equipment providers can get in crops. So there's essentially two types of statutes out there. One would be, are we improving the land by tilling it? And I'm not aware of any example ever in any state of a person who plows or tills property being able to assert a right of mechanics lien. However, I do know quite a few laws that would apply to those who grade. So if you either create like a water retention pond, or alter the contour of a property such that leveling it out, or removing impediments, boulders, or in order to make the property more tillable, then those would be improvements to property that could potentially fall under a mechanics lien law, or right to lien the actual land. If it's just straight tilling, it's going to follow under the statutes that allow liens on the crops, which we'll discuss.
Thanks, Nick. I think those are all the questions that we've received for now. Please continue to send us additional questions that come up, and feel free to reach out to us after the presentation as well with any specific questions. We have a national practice and would be happy to answer any additional questions or issues that arise.
All right, well, we'll move on and talk about the next few topics, which may be of more interest, which would be the right to assert a lien to personal property. Lawyers use the term personal property to mean effectively anything that's not paper, money, currency, or real property, which is dirt and land and buildings. So personal property can include cattle, can include tables and furniture, it can include, and most importantly here, agricultural equipment and automobiles. So there is a kind of deriving from this concept of the traditional mechanics lien on land, this concept that if I provide repair services for commercial or agricultural equipment, then I should be entitled also under the same legal theory of, the person that provides a benefit to property should be entitled to use that benefit as security to get paid. The laws became more prevalent in the later part of the 19th century that expanded this concept to liens on, at that time, more primitive agricultural equipment and later automobiles in the complex technology advanced equipment we have in use today. So that effectively would allow now I'm certainly not to use the word mechanic, a repairman, because I don't want to confuse between the old use of the term mechanics, that lien actually applies to land. That applies to the repairman. North Dakota uses that term in their statute. They call these repairman liens. And I think Michigan has like my favorite statute name for this type. They call it a lien of mechanic, artisan, tradesman, or manufacturer, which I think covers everything. So these type of liens allow the person that repairs an equipment, enhances it, alters it, upgrades it, paints it, the right to, in most states, not all, maintain possession of that equipment until it's paid for. Or two, go through a claims process very similar to what we looked at in the land lien context of stating a statement of lien, starting a lien against that equipment, and later going through a judicial process that could lead to a judgment that would allow for the sheriff to seize and sell that property in order to pay the original bill of the repairman. But again, very specific, very important to reference the specific statute at issue. And I'm confident to say that all 50 states have at least some concept of this. So everybody can avail themselves, I should say people in all 50 states, and I believe most provinces in Canada can avail themselves of this type of statute. So it's very important to understand the specific requirements in the applicable state and then follow those to the letter. We have an example on the next slide from Kansas. And again, this is a particular statute that, this in Kansas, a claimant, the repairman is defined as, any person who makes repairs or improvement to equipment or goods. It's very, very broad. It would cover not only mechanical equipment, but other type of equipment as well. The extent of the lien would be the value of the services. So if there's a $10,000 repair done to a combine, even if that combine is not in the physical possession of the party that provided the service, a lien can be attached through this particular statute that would run with that particular piece of equipment. Ultimately, if there's no payment, then there are on the next slide there are some particular processes of all in place that would allow the lien claimant to file a statement. So in Kansas, it's a 90-day standard, as we're seeing. In other states, these vary. What's kind of not shown in this example, but we see from other states, is a particular set of standards that relate to instance in which the repairman or maintains possession of the equipment. So in that state, there's another state statutes. There's specific processes that a party that wants to retain the equipment pending payment has to follow. So it's as simple as that. I mean, we'll talk about the additional example that this is the fourth class of lien that we're going to discuss, and this would be liens on the actual outcome of the use of the equipment in an agricultural context. So again, there's just great statute names. I like my favorite's Illinois. It's called the Thresherman's Lien. It goes to show how old some of these laws are. North Dakota, again, is very practical. They call this the Agricultural Processor's Lien. Minnesota has a very detailed one. They call this the lien on crops for rental value of machinery statute. And then Wisconsin, again, old school, lien on threshing, husking, and baling, which is, again, just goes to show how these laws predate a lot of the advances in agricultural equipment over the years. I don't think any of these two terms are used anymore. But these are essentially the names that I think Wisconsin's name says it all. These statutes reflect the concept that if a producer uses rental equipment, and in some cases this goes beyond equipment, it actually goes to labor. So the laborers that participate in the production of a crop, they are entitled to assert a lien against the actual product, the end product of the use of that equipment or service. I was looking at Arkansas is a great one too. They still have might be my favorite lien of all time, the cotton gin lien. I don't even think, are there cotton gins anymore? Somebody hopefully can type in, knows more about that. Our climate doesn't give well to that. But essentially, again, similar, very particular requirements. We're going to look at the next slide. Is kind of an example. This is Illinois. They call this the Thresherman. They call it the Thresherman's lien. And I mean, again, you could see the old language in this language is pulled right out of the statute, and it's available to anyone who owns or lesses a threshing machines, clover haulers, corn shellers, or hay balers. So they're using, I guess it's fair to say, archaic language to describe really anyone who provides on a rental basis machinery used in agricultural production. And the extent of their lien, there's a specific deadline in Illinois for filing the lien that's tied to the time of which the machinery was possessed by the producer. So there are specific requirements to follow, but in concept, a party that's not paid for the use of their machinery can attach, the legal term we use is attach, meaning use that end product of the production as security to get paid for the equipment used to produce those goods. I think we will move on to the next and ask if there's any questions.
I do have a few questions here. This is a good question. When work is done for a customer of another state, which law applies? For example, a dealership in Nebraska doing work for a customer in another state, which state's laws would apply?
It's a very good question, and the answer almost always will be the state of the customer will apply, because even if so for example, if the rental equipment it was rented in Iowa but used in Minnesota, under any of these four classes of statutes that we've discussed, the law of Minnesota or the law of the company or the customer would apply.
Another question.
Now, I'm sorry, I do want to just say, under that type of situation, when we're dealing with a kind of a cross-border, it's very interesting, because the law, and oftentimes counsel will think strategically about which sets of law to use, because in the discussion that we're having, the law of the state of the customer would apply, so you'd have to look up the adjoining state's law. But under any contract or purchase order that was put in place, the law of the state in which, in this case, the vendor or the dealer would apply. And so in some contexts, it may be more advantageous to sue under a contract in the local jurisdiction. especially when you're talking about, you're 3 counties over in a different state. It may be more practical to just avail oneself of the laws of the local jurisdiction. So again, this going up 2 steps beyond the question that was asked, but just to be careful in those type of circumstances to evaluate what rights are most beneficial.
Second question, when filing a lien for farm equipment repairs, do we list both husband and wife and/or all partners? So who specifically?
The kind of theoretical answer should be to list the owner of the equipment. But I would, under these circumstances, it's generally good practice to list everybody at first. So the legal structures used by some of the producers can be complex. So in that context, it would be good practice to list and provide notice to everybody who's associated with that production.
Okay, last question. How do the repairman's lien differ from work performed in our shop versus work performed in the field at a customer's location?
There's no difference as they apply to the ability to assert a right of lien in the equipment. There are some, as we discussed, there are some state statutes that permit retention of the equipment as security for payment. So if tractor is brought to the shop and there's no payment in some states, you can hold the tractor until the payment's made. If the repair is done in the field, well, obviously that it's not possible to use that part of the statute. So it's never, unless you have a judgment in the hand and the sheriff standing right next to you, it's never permitted to go onto another person's property and remove equipment, even if that equipment is subject to a lien.
Great. Those are all the questions we have now. Please continue to submit your questions. I think we'll have some time at the end to address whatever questions we have left.
Okay, well, we're going to go, having discussed this 4 classes of lien, we're going to go back and we're going to just talk about practical tips for your business or your customer's business that can allow you to either preserve rights or protect against the rights of others. So again, I think it's worth repeating, possibly for the 3rd time, that it's, everything's going to differ from state to state, and it's very important to identify applicable laws relating to statutory liens. I guess in the context of the traditional mechanics lien on rural property, again, first, in the context in which a party is acquiring construction services or other improvements to real property and land, it's essential to understand how these mechanics lien rights of either you as a service provider or as an owner of third parties come into play. So in going through this slide, I want to be careful because we're talking about kind of there's 2 things at play here. One is the context in which the equipment dealers on this line would be a consumer of construction services. So we want to protect from lien rights in that case. The other context is when there are some on the line who rent equipment, in which case we want to preserve the rights of lien. So point number 2 on this slide goes to the rental equipment providers. And one of the things when renting equipment and to preserve future lien rights is to get as much information as possible at the time of the rental. So we want to identify on the paperwork very particularly the actual equipment that's used. That's important in some places. So we want to know the owner. We want to know where the equipment is going to be used. What is the physical location? Where is the dirt going to be moved? Where is the crane going to be placed and move equipment and supplies onto the property? In some contexts, we might even want to know if it's a bonded project, especially in the context of any public improvement. And in every place in the United States I'm aware of, public projects need to be bonded by a surety that assures payment to suppliers and subcontractors. So if any equipment is going to be used for a public project, we want to identify the bond that was placed in that property. Kind of one important note I left out when discussing mechanics liens is mechanics liens generally never can be asserted against public property. So if equipment's being used to build a new playground on a public park, well, obviously there's no mechanics liens that can attach to a public property. The substitute under our legal system is that the party that's is given the contract to build the new playground in the public park needs to provide the city with a bond, making sure that all the subcontractors and suppliers get paid. So that's a practical tip for rental equipment providers. We're going to move to before moving on to the next slide, just in terms speaking to the context in which we're not protecting ourselves against lien as an owner of property building that new showroom or warehouse or repair facility. It's extremely important to make sure in the construction contracts that there's a requirement for the general contractor to provide lien waivers from all subcontractors and suppliers. That should be written. I'm sorry, can we skip, my apologies, can we skip ahead 2 slides? We're a little, I'm sorry, this is someone out of sequence. So, as I was saying, I was speaking to point 2. The construction contract should make sure that the general contractor has to go through, has to provide lien waivers from all subcontractors and suppliers before collecting payment. There's also an ability in the construction contract to hold back retainage from each progress payment that can be used as security against liens that could pop up later. Owners in this context can be very diligent in collecting those lien waivers and comparing them to the amount of funds that have been outlaid with the goal of only paying for the work that has been performed and completed and for which lien waivers have been provided. As noted in point 4, in some complex projects, it's helpful to use a third-party disbursement agent who are often attached to title companies with lenders, but not necessarily. If there's no lender involved, there's still opportunity to bring in third-party disbursement agents to make sure that this occurs. And then under point 6, sometimes it's a good idea to bond your project. This requires a contractor to post a bond that says that they're going to complete the project as they are contracted to do and keep the premises free of liens. If there are liens asserted against the property, then the bond issuer or the surety, is a technical term, would be required to step in and satisfy those liens. So for a 1 to 3% upcharge in price, that amount of additional security is available. And then again, just now we need to go backwards. My apologies. We'll talk about some takeaways and best practices for to preserve interest in crops or lands. Again, just to say this multiple times, there's a particular statute in your particular location, or importantly, in location where the crop is going to be grown, that provides specific requirements. Understand those specific requirements are essential. Then again, similar to the context of we're not going to be in availability to serve, it's important to identify who's going to use the equipment and what context is not obvious. And most importantly, where in collecting this information at the time of rental, go through the steps necessary to assert a lien against the crops and product to preserve your lien, is very good practice. And I think we should open up to questions.
With this last section of slides, so I will read 2 questions that are somewhat related, Nick, and have you address those first. The first is, does a dealership have any recourse against the customer's written signature approving the repair?
Yes, it just requires the agreement are obviously more difficult if there's no writing that signed writing. Those are not always required to form a contract. There could be activity at a facility or making it available for repairmen to provide services. Technology acquiescence to the performance of the service of making that equipment available and affirmations that there was an intent to submit that equipment to the service. Verbal contractual agreement.
Okay, the next, we've got a couple questions about signatures to repair. Here's one of them. Does the customer have to sign a repair order for a lien to be?
On this one, again, it's reference to specific state laws may be necessary. There are some statutes that require a signature in order to avail of specific lien rights. But as a general rule, that's not the case. So can you repeat the question? Was there a signature on the repair?
If it's not a signature on a repair order, can you still enforce it?
I mean, I would, yes, because at some point the repair was requisitioned, it was requested. I mean, even if there's not a paper that validates that, there is actual facts and occurrences and events that existed or took place that made it obvious that, you know, the party was requesting the service, and that is generally not 100% ironclad, but generally enough to avail of some of these state statutes that we've talked about.
We have a state-specific question. We'll quiz Nick's knowledge on Michigan law, which we may need to brush up on. But the question is, in Michigan, how long can you hold tractors or equipment that have been repaired? Can you give notice to the owner that the equipment will be sold for the repair bill? Can you then give notice to the owner that the equipment will be sold for the repair bill? Well,
that's such a specific question. I'm not comfortable.
Quoting Michigan law.
I'm not comfortable. I'd have to go back and verify. But as a former resident of Mecosta County, Michigan, I'm a little disappointed. I don't know that off the top of my head.
Well, we'd be happy to look into that specific statute for you. Next question. Do we have a list per state to find out what liens are available and what the rules are?
I'm going to give a shout out to the National Ag Law Center, which is affiliated with the University of Arkansas. They have a tremendous website. Now, I think I can say this verbally. It's National Ag Law Center.org. National Ag Law Center.org. They've got some tremendous summaries of the various state laws, and I think they're connected with the School of Agriculture and the School of Law in University of Arkansas. Great reference. Very easy to find your state and obtain a reference summary of the various state laws. I don't think that they look at Canada or any of the territories in the U.S., but it's a very, very good starting point. I would give a word of caution that they give a very high overview of the laws that are available and the basic requirements, but as a practitioner that's done this for several years in a few jurisdictions, there's a lot of pitfalls because the case law, the history of judicial opinions over the years have changed the interpretation of some of the state statutes and added, as we mentioned before, the waiver doctrine in Missouri of priority. That doesn't appear in the statute. So I would recommend consulting with legal counsel prior to going forward with asserting lien rights, or potentially even to review purchase order forms, construction contracts, definitely, to make sure that the rights are either best protected or preserved, as the case may be.
Thanks, Nick. We have one last question. What recourse does the dealership have when the equipment that was repaired is valued less than the actual repair costs associated with that equipment?
Well, this, in the land context, comes up quite a bit, and I would imagine also with rental equipment as well. Going through the logical, so this could play out in one of two ways I can see. One is if the repair is worth more than the actual equipment, well, the customer may just, if it's a situation in which the repairman can retain possession of the property, then the property may just be abandoned. Then there are steps that you can take to sell the property outright under the statute, or go through a formal process to have the sheriff take the property off your hands and sell it. The other example would be when the repairman cannot maintain possession of that property,
then if a lien attaches and there's a judgment for the value of that lien, then the sheriff sells the property. Let's just use round numbers. Let's say the property's worth, $10,000 and the repair was $20,000. If that equipment was sold for $10,000 at a sheriff's auction, the first $10,000 would go to the lien holder to satisfy in part that lien. Then the other $10,000 can be collected personally from the owner of the equipment.
Great, thanks, Nick. We have a couple specific questions, which I think we'll answer privately rather than discuss to the group. Anything left? Any other?
No, I think.
Well, thank you very much, Carolyn and Nick, for your presentation. I know everyone found it to be very informative. If you are interested in obtaining more in-depth assistance for your dealership to ensure that your policies and procedures comply with the applicable state or provincial law in your area, I would encourage you to reach out to Nick and Carolyn directly to inquire about their available legal services. And then we're also available as a resource here at EDA for our dealers. So if there's no other questions, we'll go ahead and conclude, and thanks everyone for attending.